Thank you very much, Justice Trivedi. Our final speaker for the plenary session, Justice Shah, Judge, Supreme Court of India. Justice Shah was appointed as an additional judge of the Gujarat High Court in 2004 and made permanent in 2005. He was appointed as the Chief Justice of the Patna High Court in 2018 and elevated as a judge of the Supreme Court in the same year. Before his elevation as a judge, Justice Shah practiced for over 20 years in the Gujarat High Court in civil, criminal, constitutional, taxation, labour, service and company matters, specialized in land, constitutional, education, excise and custom disputes. Justice Shah, we will invite you to the stage.
Namaskar. A very warm good morning to all of you. My colleague in the Supreme Court, Justice Bela Trivedi, Judge Supreme Court of India. Chief Justice Aravind Kumar, Chief Justice of the High Court of Gujarat. My dear Tushar, Mehta, Solicitor General of India. Dear Kamal, Lord Advocate General, brother and sister judges of the High Court of Gujarat, Honorable former judges of the Supreme Court and the High Courts, Shri Asim Pandya, President Gujarat High Court Advocates Association, Shri Mcia, Office Bearers of the Mcia, organizers of the conference, other participants from the corporate field as well as the legal law firms. Ladies and gentlemen, it is a privilege to be invited to address the second annual conference on international commercial arbitration, the way forward, organized by Mcia in collaboration with the Gujarat High Court Arbitration Center and the Gujarat High Court Advocates Association. It is an honor to have been invited to deliver an address on the very important subject and address the August gathering. The present day discourse on the need to evolve alternative dispute resolution mechanisms tends to focus upon the large and almost unmanageable docket of litigation before the courts. The rationale for ADR is perceived in terms of reducing the arrears of cases in courts. The problem of arrears has necessitated a search for alternates. The ultimate goal for justice delivery system is low, cost-effective, and timely resolution of disputes. To achieve that goal, one is required to find out the other ways. The problems which arise in the resolution of disputes through litigation are well known. These are broadly delay, expense, rigidity of procedures, and a reduction in the participatory role of parties. The business disputes, external or internal, if not resolved at initial phase, may ultimately drag the organization into a protracted court battle. The present adversarial court litigation system, which is characterized by inordinate delays and high litigation cost, not only consumes the time and money of the parties, but also potentially destroys the long-term business relationships. The increasing growth of global trade and the delay in disposal of cases in courts made it imperative to have the perception of alternative dispute resolution system, more particularly in the matter of commercial disputes like the arbitration, etc. There is a consensus in the business community that the arbitration is the principal method of resolving commercial disputes. India is waking up to the realization that its dispute resolution system needs to keep pace with its rapid economic growth. Whilst its economy grows at an impressive rate, the Indian justice delivery system has struggled to keep pace. It is therefore but inevitable that there is a huge market demand for a speedy and effective method of dispute resolution as an alternative to litigating before the court. In recent times, the arbitration has presented itself as an efficient private sector alternate to the public justice delivery system. Therefore, today more and more business owners go for alternative disputes resolution procedures like arbitration, etc. for resolving the disputes at an early stage rather than going for litigation. The arbitration is one of the widely accepted methods of dispute settlement. While settling the business disputes through arbitration, the benefits are: it is cost effective, speedy, fairness, finality of award, simple procedure, confidentiality and specialization. Today, arbitration is a popular mode of arbitration, alternative ADR, in the commercial world, and one can find an arbitration clause incorporated in the majority of the business contracts. In India, the most popular form of arbitration is an ad hoc arbitration. However, there is an increasing trend of adopting the institutional arbitration also. If one has to try to strike the balance between the ad hoc arbitration and the institutional arbitration, according to me, the benefits in the institutional arbitration would be more than in the ad hoc arbitration. As such, there is no much difference between the ad hoc arbitration and the institutional arbitration. It is merely a difference in the method of appointment and conduct of arbitration. In India, like the courts, many a times ad hoc arbitration is accused of riddled with problems of delayed proceedings, unprofessional arbitrators, resulting in poor quality of awards. This means these issues make ad hoc arbitration vulnerable to excessive court intervention at all stages of arbitration proceedings. Why one should prefer the institutional arbitration is that it is cost effective and time saving. There is a discipline in the arbitration proceedings and the transparency. In the ad hoc arbitration, for a variety of reasons which may be attributed to the parties themselves or the lawyers or even many a times the learned arbitrators, and no clarity and or uncertainty on the procedure to be followed, proceedings are delayed and ultimately it affects the parties for which the arbitration is invoked. Low cost and timely resolution of the disputes. Following are the major advantages of the institutional arbitration. Availability of pre-established rules and procedures which assure that arbitration will cut off the ground and proceed to conclusion within the time schedule. List of qualified and professional arbitrators, often broken out by fields of expertise, are available. Appointment of arbitrations by the institution should the parties request it. Administrative assistance from the institutions, providing a secretariat or court of arbitration. Physical facilities and support services for arbitrations. As there are pre-established rules and procedure under the institutional arbitration, the parties and their lawyers save the effort of determining the arbitration procedure in view of the rules which the parties know and that there is no ambiguity in relation to arbitration process. Another significant benefit under the institutional arbitration is selection of arbitrators. In institutional arbitration, the arbitrators are selected by the parties from the institution's panel of arbitrators, which comprise of expert arbitrators from various regions of the world and having a technical knowledge in the field. This ensures selection of arbitrators possessing requisite experience and knowledge to resolve the dispute, thereby facilitating quick and effective resolution of the disputes. Other benefit is timely appointment of arbitrators. A judicial notice can be taken that even for getting the appointment of arbitrator in an ad hoc arbitration, the parties have to move the High Court, and it takes months even, not only months, it is my experience even years together, even to refer the dispute to the arbitration and get the arbitrator appointed. I may share my experience, recent experience, and recently I have passed an order calling the particulars from all the High Courts of the pending 11-6 matters. It is hard reality that in the various High Courts for more than 4 to 5 and 6 years, the 11-6 applications are pending for determination. Recently, we have dealt with a matter in state of Telangana, 2014 matter. We, Supreme Court, I myself and other judge, appointed the arbitrator in the Supreme Court and disposed of the matter in the High Court with the consent of parties. Recently, we have delivered one matter came before us. Application under section 11(6) was made in 2016. It was dismissed in 2020. Matter came to the Supreme Court, and we have to consider whether the dismissal of the arbitrator or 11(6) application was right or not. Suppose ultimately after 2-3 years we decide that yes, the 11(6) application was required to be allowed. Correct? What is the use of Arbitration Act? For what purpose the Arbitration Act is there? Why the matter is to? Because ultimately we face the situation in the litigation that we are not delivering the timely justice. That is why the arbitration. If for 5 years or 6 years the arbitrator is not appointed under section 11(6), correct? And we come out with the Arbitration Act amendment that within 1 year the arbitrator has to dispose of the arbitration proceedings, correct? What is the point of those procedures when we are not in a position to appoint the arbitrators under section 11(6)? These are the reasons why, correct, the institutional arbitration gives the time. That okay, come here, correct, we will appoint the arbitrator immediately, and immediately the process will start. So far as the institutional arbitration is concerned, apart from the fact that there is a discipline in an arbitration proceedings, there are no unnecessary adjournments, which ultimately not only delay the proceedings, but it will burden the parties financially also, which can be avoided if the institutional arbitrator is accepted. Tushar Mehta has rightly stated, and I entirely agree and endorse, that because of non-availability of the time, the proceedings have delayed, and it has gone beyond 1 year, 2 years and 3 years. For whatever reason, we are not attributing anybody, correct? Everybody is busy, they are overburdened, and because of them, they are not in a position to give the time. Why the arbitration proceedings cannot be decided in day-to-day basis? The another reason is we have not accepted the arbitration proceedings and the ad hoc arbitration as a permanent alternative system. Unfortunately, we have accepted it as a part-time the alternative dispute system. Tushar Mehta is saying that trained advocates are there and we should give the training. I know that so far as the Mumbai is concerned, correct, the young advocates, correct, are actively participating and they are associated, correct, with the arbitration proceedings. Not in the evening, correct, but it's in the daytime also they have changed their profession. Then they have permanently joined the arbitration, and it ultimately helps the early resolution of the dispute between the parties. Both ad hoc and institutional arbitrations are prevalent in India. However, in terms of cost benefit, expediency, efficiency and hassle-free mechanism for dispute resolution, the institutional arbitration might have its upper hand over ad hoc arbitration. As the ad hoc arbitration has become costly and time-consuming, the wisdom communities and the Indian corporate houses have started rethinking of having arbitration clause incorporated in the agreement. This is a very dangerous scenario. Therefore, a day has come now to think of an alternative solution, and the institutional arbitration can be a substitute. I may share one another recent experience also. After 6 years of arbitration in the Bombay, the arbitral tribunal was consisting of 3 members. For whatever reason, one honorable arbitrator has died, another resigned, third resigned. After 6 years, correct, the parties came before the Supreme Court for nominating the arbitrator. Ultimately, the parties said, both the parties said, that, sir, it is enough now, correct? Please, we are with the consent of the parties, correct? We are ready to go for a single member arbitral tribunal. Why this? After 5 years, because they are tired now. They went to the arbitration, correct? Ad hoc arbitration for the, so that they wanted their business dispute to be resolved urgently, but they could not achieve the result. That is why, and I am not exaggerating anything, but correct, they are now coming in with the cases, sir, correct, now we are rethinking that whether arbitration clause will be there or not. I am not at all against or criticizing the ad hoc arbitration, but my experiences as a judge of the Supreme Court, as a High Court, as well as the High Court and the Supreme Court, I am led to believe that the ad hoc, the institutional arbitration might be proved to be better than the ad hoc arbitration. Number of variety reasons of that, we may not enter into that question for which we will be discussing today. However, one cannot turn away from the hard reality that ad hoc arbitration has become costly and time consuming. There may be variety of reasons for ad hoc arbitration becoming costly and or time consuming. Maybe due to one of the parties to the arbitration proceedings trying to delay the matter, asking for adjournments, and the learned arbitrators are overburdened. However, so far as the institutional arbitration is concerned, the rules and procedure are known, fees are known, there is a transparency, confidentiality, and observed in above, there is a discipline, and parties may not have to suffer due to delay and cost, etc. With India being a promising destination for foreign investment, it is essential that India's arbitration law is aligned with the contemporary international practice. Fear of prolonged litigation in case of disputes. Such a response to the changing requirements will ensure a promising future for India as an honorable destination for arbitration and can become a game changer for the progress of our country as a developing nation. It is very unfortunate and it is a hard reality that international commercial dispute, international market is concerned. They are not accepting our institution. They are not accepting our system as a whole. Tushar Mehta has said, and the Chief Justice has also said that they have come out with an arbitration center, and we must come out with the hub, and we all facilities and infrastructure to be provided. I entirely agree that infrastructure should be provided, but at the same time, we have to change our attitude. We have to accept, correct, we have to think a day has come to inspect ourselves. Where are we lacking? Where are we missing? Where are we failing? So that we do not match with their standard. Everybody is talking about why everybody goes to and select international market. They go and select the Singapore because they are sure that procedure is there, correct? Dedicated arbitrators are there, maybe advocates also, maybe learned judges also, everything, correct? But they are dedicated there. They know within this time, correct, I will get the result. And there is a minimal intervention so far as the court proceedings are concerned. We have also now, Supreme Court has also come out with number of judgments also and minimal intervention also. But there also I have my own doubt, correct, that to give full, freedom and finality at the stage of 34. It's true that it should be minimal, but that does not mean, correct, that we should raise our hands, correct, and say, no, arbitrator has done this, therefore we will not do it. In a given case, we have to do it. We do not know what has happened, whatever it may be, that ultimately, but we have to change our attitude. We have to see to it that we may come at par with with the Singapore model or foreign model. Unless and until we give them the guarantee, correct, the international market will not accept us. Still we are trying our best, our government is also trying our best, and I am told that GIFT City, they are coming with some international arbitration center also. Such a response to the changing requirements will ensure a promising future for India as a favorable destination for arbitration and can become a game changer for the process of our economy as a developing nation. A robust arbitration regime in India would eliminate the possibility of investors having transactions in India to resort to arbitration elsewhere, since it would not only be convenient and time-saving but also inexpensive. Therefore, it is a time to promote and market India as a world-class facility for arbitration, and for which there must be international arbitration centers like Mcia and other institutions in the country. For whatever reason, the institutional arbitration has not got momentum. The advantages of the institutional arbitration must be well publicized. I hope and trust that such conference like the today's conference will cater to the need and the institutional arbitration gets momentum. It is widely accepted. Today, you will discuss on the subject where the world arbitrates. I am sure that in today's conference and seminar, you will also introspect, correct, and think and discuss, correct, how to make Indian arbitration at par with the international arbitration. How to make our arbitration, correct, like the Singapore arbitration. Why we are international arbitration is still, correct, accepting the seat and venue at Singapore. Why? We have to introspect that, and I am sure in today's conference all of you will introspect, correct, and come out with some solution, correct, and so that we can be at par with Singapore model. Why everybody is Singapore is saying we buy the litigation. Why the litigation means because they guarantee that the dispute resolution dispute will be resolved at the earliest. Many a times the corporate worlds are not concerned with money only, but they want the early resolution of the dispute in the business, so far as the commercial business is concerned. So in the today's conference, I am sure that all these things will be discussed. I hope and trust that such conference like today's conference will cater the need and the institutional arbitration gets momentum. The structures of this institution need to be strengthened through resolute efforts and consistent alertness. This institution has a much higher role to play, that of upholding the arbitration process and timely and cost-effective resolution of the disputes with minimum intervention of the courts. I am happy that today's conference is with the collaboration of the Gujarat High Court Arbitration Center as well as the Gujarat High Court Advocacy Association. I request both of you, the Mcia as well as the Gujarat High Court, when Honorable Chief Justice is here, and the Gujarat High Court Arbitration Center to work together in furtherance of the alternative dispute resolution system. I request the organizations of the Mcia also to take the benefit and advantage of the infrastructure and other facilities which will be provided by the Gujarat High Court Arbitration Center, and I am sure that it will help the Mcia and ultimately, because ultimately both are institutional arbitration, both have to go together. My best wishes to the such international arbitration institutions and the conference. Once again, I am thankful to the organization for giving me this opportunity to address this august gathering and share my views on the subject. I am extremely sorry if I have spoken something which might not be liked by so many or other things, but whatever I have said from the bottom of my heart and from my experiences as a judicial, as a judge, High Court judge and the Supreme Court. Thank you all for giving me this opportunity. Thank you.
Thank you very much, Mr. Justice Shah. Now we'll have a short video by the Gujarat High Court Arbitration Center. Thank you very much. May I now request Ms. Neeti Sachdeva, Secretary General Registrar, Mcia, to render the closing remarks of the plenary session.
Respected Justice Shah, Judge Supreme Court of India, respected Justice Bela Trivedi, Judge Supreme Court of India, respected Justice Aravind Kumar, Chief Justice Gujarat High Court, Mr. Tushar Mehta, Solicitor General of India, Mr. Kamal Trivedi, Attorney General, Mr. Asim Pandya, the President of the Gujarat High Court Advocates Association, distinguished judges of the High Court, ladies and gentlemen. It is indeed a gratifying to see a full house on a Saturday morning in Ahmedabad. I would like to thank every one of you for sparing your time to be present here for this very important theme and conference on international commercial arbitration, a way forward. I'm very delighted to inform you that we had such an overwhelming response that we had to close down our registration, in fact, a day before. Justice Trivedi, Justice Shah, and also Mr. Mehta, they spoke about the advantages of institutional arbitration. Over the last 5 years of our inception, MCIA has believed in cooperation and collaboration and promoting the use of institutional arbitration. And keeping with our commitment to this collaboration and cooperation, we partnered with the Gujarat High Court Arbitration Center to bring this conference to you. Mr. Mehta also mentioned that we should be looking at establishing India as a hub of international arbitration. I'm very delighted to inform you, sir, that in the last 5 years, MCIA has been doing international roadshows in countries like Singapore, London, Germany, Dubai, Japan, and Korea, and we've got a superb response from all these jurisdictions of promoting arbitration to be seated in India. And we assure you we'll continue to do that in future as well. MCI has also led the initiative to create an ecosystem for the establishment of an arbitration bar, and our partnering with the Gujarat High Court Advocates Association is in that direction to make sure that maybe Gujarat will lead the initiative to be the first bar to have a dedicated arbitration bar. The Chief Justice also mentioned about how we need to train the arbitration lawyers, and we are hoping that with the bar we will be able to partner more in the future to create more workshops where we can talk about the practice of arbitration itself. We also heard our dignitaries talk about how India cannot be ignored and how India is the future. You all will agree with me on this fact that the future lies in the hands of the young generation. And with this, we have something called as the YMCIA, with the motto being that catch them young, train them young. So we do create workshops, training programs for young lawyers so that they can imbibe the practices and the best practices of international arbitration right at the beginning of their career itself. Last but not the least, we have also launched the MCIA User Council, which is our way of connecting the users of the different industries from across the globe who are facing similar challenges in their industry and are looking for solutions in resolving their disputes in an efficient manner. We have launched in the field of maritime, infrastructure, energy and power, FMCG, realty, TMT and automotive. In fact, one of our sessions today is being hosted by the MCIA Maritime User Council. Let me conclude by narrating a story. There was a sign on a shoe repair shop in downtown Boston, which was run by an immigrant, and he was fed up of the complaints he received from the customers. So what he did was that he put a signboard outside his shop, which was in a form of a triangle. And on the three edges of the triangle, he put 3 marks, which was fast service, low price, high quality. And he mentioned below, please pick any 2. I assure you this may have been the situation of arbitration in India, but with institutions like MCIA, institutions like Gujarat High Court Arbitration Center, this is not so anymore. We will provide you all these 3 services in a very efficient manner. I also would like to talk about what Justice Shah spoke about, how it is important in efficiency in arbitration and not only appointing arbitrators but appointing them in a timely manner. Sir, I would like to tell you that MCIA, we take decision making with our council and our secretariat, and our council consists of judges, lawyers and practitioners from around the globe, and I have a secretariat which also has an experience of working in different arbitral institutions. Trivedi, Vice President of the Gujarat High Court Advocates Association, and specifically Mr. Mehta for their confidence in us and their support, and without whose support we would not have been able to put this together. Last but not the least, a very big thank from the bottom of our heart to the Board of Governors of the Gujarat High Court Arbitration Center, with the Patron-in-Chief, the Chief Justice himself, the President, Honorable Justice Padiwala, Justice Desai and Justice Bhargav Karya for their support, and especially Mr. Doshi for being on the ground to help us with everything. With that, we conclude our plenary session. Thank you once again for supporting and for being here. Thank you.
Thank you very much. We kindly invite you all to join us for tea and coffee at the pre-function area outside this conference hall. We'll start the next session, the first technical session, at 11:35 sharp.